to hearsay. As you noted in your opening remarks, Mr. Chairman, the burden is no longer on the opponent to demonstrate that hearsay should be excluded. There is a notice requirement in the proposed legislation, and if the proponent of the hearsay can demonstrate reliability, materiality, and that the declarant is not available as a practical matter, given the unique circumstances of military operations and intelligence operations, the hearsay could be admitted. Military commissions are fundamentally different from UCMJ courts in that most often what you have in military justice is the punishment of a member of the U.S. military for some violation of the UCMJ, very often directed, of some sort of domestic nature. And military commissions, obviously, for violations of the law of war, they're very often prosecuting people captured on the battlefield, and just given the nature of the way evidence is collected, there needs to be a recognition that the military can't be expected to change how it does business to engage in evidence collection on the battlefield. So the way this legislation deals with the hearsay rules, I think, is quite appropriate and is certainly an example of evident practical need. I would say the same when it comes to the rules on authenticity set forth in this proposed legislation. There's not a requirement like you would see in UCMJ courts or in civilian courts for what we in civilian courts would know as a strict chain of custody. There is a more practical approach given the needs of military operations and intelligence collection. And
can I interrupt you there because of our short time? If there are any, if you could expand for the record, sure, any places where you believe that there's, where we fall short of complying with the Hampden standards, I'd appreciate that. If you could do that for the record. You could expand your answer too, but I'm
sorry for going on so
long,
got 6
Senator. Mr. Chris, let me ask you, representing the Department of Justice, in your judgment, do you believe that this bill, as drafted, that these provisions conform to the Hampden standards?
Yes. To the extent that the uniformity principle from Hampden applies to a statutorily created system of commissions, I think it is met here. Jay mentioned some of the differences, and I think his justifications make sense. We have some recommendations for change, but those aren't rooted in the uniformity principle at all.
Okay, and while I'm asking you questions, it's been argued that it's not appropriate for the Department of Defense to prosecute terrorists. Do you believe that it is appropriate for the Department of Defense to prosecute alleged terrorists with these military commissions instead of the Department of Justice doing all the prosecuting in Article III courts?
Yes. I think the President made clear in his May 21st speech that we will prosecute in federal court, and where there is a law of war violation and under a reformed system of military commissions, we will also prosecute law of war violations in those commissions. I think the President said it best when he said that we need to be using all instruments of national power against this adversary, and that includes military commissions.
Okay, thank you. My time's expired. Senator McCain.
Well, thank you, Mr. Chairman. Mr. Johnson and Mr. Chris, if trials were held in Guantanamo or the United States, would there be any difference in the proceedings?
Senator, if military commissions were held in the continental United States, I think that we have to carefully consider the possibility that some level of due process may apply that the courts have not determined applies now. I think that assessment has to be carefully evaluated and carefully made. I think that.
So what you're saying is that you believe there could be some significant difference in procedure if the trials were held in Guantanamo or the United States of America?
I'm not sure I would be prepared to say significant difference, Senator.
Well, I think it would be important for this committee to know what your view is it might have something to do with the way that we shape legislation. If they're going to have all kinds of additional rights if they are tried in the United States of America as opposed to Guantanamo, I think that the committee and the American people should know that.
One of the things that I mentioned in my prepared statement, Senator, is that when it comes to the admissibility of statements, the administration believes that a voluntariness standard should apply that takes account of the realities of military operations. And we think that that is something that due process may require, particularly if commissions come to the United States, that the courts may impose a voluntariness standard.
Well, I hope that you and Mr. Chris will provide for the record what you think the differences in the process would be as to the location of those trials. I think it's very important, certainly is to me. Mr. Chris, in your statement on page 2, you said there's a serious risk that courts would hold the admission of involuntary statements of the accused in military commission proceedings is unconstitutional. Does that infer that these individuals have constitutional rights?
I mean,
they do. What are those constitutional rights? People who are not citizens of the United States of America, who were captured on the battlefield, committing acts of war against the United States.
Our analysis, Senator, is that the Due Process Clause applies to military commissions and imposes a constitutional floor on the procedures that would govern such commissions, including against enemy aliens.
And what would those be, Mr. Chris?
Well, there'd be, I mean, a number of due process-based rights, one of which Mr. Johnson just mentioned is we think there is a serious risk that courts will find that a voluntariness standard is required by the Due Process Clause for admission of the...
So you are saying that these people who are in Guantanamo, who were part of 9/11 or have committed acts of war against the United States are entitled to constitutional rights of the Constitution of the United States of America?
I mean, within the framework that I just described, I think the answer is yes. The Due Process Clause guarantees and imposes some requirements, that's the way I think I would put it, on the conduct and rules governing these commissions.
Well, that's very interesting because I had never proceeded under that assumption in drafting this legislation and previous legislation. The fact is that they are entitled to Geneva protections under the Geneva Conventions, which apply in the rules of war. I did not know nor know of any time in American history where enemy combatants were given rights under the United States Constitution.
I mean, I do think, Senator, there's a difference between their rights. For example, they would not be entitled to the rights under Geneva for prisoners of war because these are...
No, they are rights under the treatment of enemy combatants. Those are Geneva Conventions, Common Article 3.
Yes. Okay. Thank you.
But we now have established that it is the view of the administration that enemy combatants or belligerents, whatever the new name that you'd like to call them, are now entitled to rights under the United States constitutional rights of U.S. citizens.
Well, not at all. I don't think that's right. I mean, both in terms of how we would describe this is as a due process requirement that applies to the commissions, even if they are prosecuting enemy aliens. And also, I don't think it's right to equate the rights or the rules that are required for commission proceedings against aliens necessarily with those that would apply against U.S. citizens. Those might come out differently. This is an extremely complicated area of law, as you know.
It certainly is, Mr. Chris, but your statement, for the record, was it's the administration's view that there is serious risk that courts would hold that admission of involuntary statements of the accused in military commission proceedings is unconstitutional.
Yes.
Therefore, it means that they have some constitutional rights. So, Mr. Chairman, I know that there are other questions by the witnesses, and if there's a second round, maybe I'll take advantage of it. Thank you, Mr. Chairman.
Thank you, Senator McCain. Senator Lieberman.
Thanks, Mr. Chairman. Thanks to the witnesses. Mr. Johnson, let me begin with a expression of appreciation for the process that the administration has gone through to come to the point that you're at today. For me, as we've gone through this, deliberation about how to treat what I call prisoners of war, that is, those suspected of violating the laws of war. It seems to me that we've had a hard time putting this in the context of our own sense of fairness related to the unique war we're in. Obviously, this is a war against terrorists. They don't fight in uniform. They don't fight for the most part, for nation states. And this war may go on for a long time, but nonetheless, it seemed to me along the way that there was no sense to those who were arguing that these individuals apprehended for violations of the law of war should be tried in our federal courts. They don't, in the sense that Senator McCain has just said, I don't think they have the constitutional rights that we associate with American citizenship. Also, they've not, in my opinion, violated federal criminal law. They violated the laws of war. So that I know that there were some who expected that the Obama administration's review would end up recommending that all of these cases go to federal court. And I appreciate the fact that you have not come to that conclusion. Although I have some questions about some of the subparts of what you've done. But I think this is really a very significant, very open-minded, very fair, very ultimately historic process you went through and reached, I think, generally speaking, the right balance, and I appreciate it. You were asked just a moment ago whether you thought that the military commission provisions of the National Defense Authorization Act were within the Hamdan ruling of the Supreme Court. I want to ask you whether your judgment is that the military commission provisions of the NDAA are within the requirements of the Geneva Convention.
Yes, Senator, with room to spare, yes. And one of my personal objectives, frankly, is that we devise a system that comports with the Geneva Conventions as well as Hamdan, as well as applicable U.S. laws. So I think the answer to your question is yes, sir.
Well, I thank you for that answer. I agree with you, and I particularly appreciate that the clause you added, which is that the military commission provisions of the National Defense Authorization Act are not only within the requirements of the Geneva Convention, but, as you said, with room to spare. I agree that we hold ourselves to very high standards, sometimes standards that are so high that they are unrealistic and in some sense self-destructive in the context of the war we're in. But I agree with you that what we've provided for this in this legislation of this committee is well within the Geneva Convention. Let me ask you a specific question that came up in the last exchange and testimony of Mr. Chris. In light of the judgment of the Supreme Court in the Hamdan case that certainly to me suggested approval of the Court of Appeals for Armed Forces as the place that the accused here can appeal from a judgment of the Military Commission, and the Court of Appeals for Armed Forces is not a standard Article III federal court, as you well know. Why is the administration seeking a right of appeal from the military commissions to Article III federal courts? Mr. Chris or Mr. Johnson?
Senator, let me take a stab at that initially, at least. First, we agree and endorse the position expressed in the bill that should be an expanded scope of review, review of the facts as well as the law. Our view is that we should retain the Court of Military Commissions review and then have appeal directly to the D.C. Circuit. That would be, in effect, a four-tiered level of review, beginning with the trial court, and in our view would resemble in many respects UCMJ justice, because you have that intermediate level of appellate court rather than an appeal directly from the military commission's trial level court to the CAF. So it would be our preference to have an appeal directed to the D.C. Circuit. But we agree with the concept of the expanded scope of review.
Is it fair to say then that the administration's suggested changes in this regard are not rooted in the Supreme Court's uniformity principles as stated in Hamden, but they're rooted in some other requirement or some sense of the administration about what's fair and just here?
I think that's a fair statement, Senator.
Let me ask you just to comment, to go back to what I said at the beginning and just describe in the time that's left on my questioning period why you reached the judgment on the behalf of the administration, or why the President ultimately reached the judgment that these cases that we're talking about should not primarily go to our federal courts.
Well, as you probably know, the President signed an executive order mandating a review of each detainee's situation. That review is ongoing. And as you've seen in at least one instance, a detainee who had a pending military commissions case against him was transferred for prosecution in the Southern District of New York. I think it is fair to say that what the President and the administration have concluded is that at least some of these detainees should be prosecuted for violations of the laws of war, that military commissions justice is the more appropriate forum, dependent upon a variety of factors. In some situations, you have a situation where a detainee has violated both Title 18 and the laws of war, and we want to retain military commissions as a viable and realistic option, whether almost everyone or everyone who is now a pending military commissions defendant will stay that way. I couldn't say. The review is ongoing.
Thanks. I want to just close the loop on the previous question because my time is up, which is that I think the committee has made the right judgment in saying that the right of appeal from the military commission should be to the U.S. Court of Appeals for the Armed Forces, and that there shouldn't be an appeal to the Circuit Court for the D.C. District. Thank you.
Thank you, Senator Lieberman. Senator Graham.
Thank you, Mr. Chairman. I'd like to, compliment you and Senator McCain for trying to come up with a new bill. I think it would help the country if we could reform the process, and I think we're very close to a bill that we all can be proud of. About the appeals, the main thing for the public to understand is that any verdict rendered in a military commission trial will work its way into the civilian courts. Is that correct?
Yes, sir.
So no one will be imprisoned in this country based on a military commission verdict that does not have a chance have their day in federal court, civilian court.
Assuming they appeal, that's correct, yes, sir.
Right. Okay. Now, when it comes to the idea of location, the courtroom at Guantanamo Bay is uniquely set up, I think, to do these trials. I would be interested to get your thoughts about how the location would matter. I'm not so sure after the Supreme Court decisions treating Guantanamo Bay as an extension of the United States that it would matter greatly. So I like Senator McCain, I'd like to know how location would matter. Admiral McDonald, one of the issues that we're grappling with is the material support for terrorism, and I think I understand the administration's view that that is not a traditional charge under the law of armed conflict, but under the Uniform Code of Military Justice, we incorporate the Assimilated Crimes Act. Could that doctrine be used here?
Yes, sir. You could incorporate it in under Title 18 through the Assimilated Crimes Act into the UCMJ, and it could be charged.
And I think, Mr. Johnson, that gets back to your point. Some of these people can be charged under both sets of laws. And is that what you were trying to tell us?
Yes, sir.
Now, Mr. Chris, do you agree with that theory that we could use the Assimilated Crimes Doctrine to incorporate material support using a Title 18 offense?
I think you could do that as a formal matter. There still remains the question whether material support historically was a law of war offense under that label or a different label.
I totally agree with that debate, but if you were able to incorporate Title 18 offenses, that would resolve that issue. Isn't that correct?
It would, again, to the extent that it's a viable law of war offense.
Okay. Yeah. All right. Thank you. Now, when it comes to evidentiary standards, are you familiar with the Hague procedures when they try international war criminals?
I'm not.
Well, one thing I would suggest that you look at, I think our hearsay rules are much more restrictive, quite frankly. Do you agree with that, Admiral McDonnell?
Yes, sir, I do. We talked about this in 2006. We looked at the International Criminal Tribunal for Rwanda and for Yugoslavia, and both of those tribunals have very liberal hearsay rules.
And when it comes to involuntariness, what kind of standard do they use in terms of admitting statements from the accused?
It's the reliability of the statement.
The point I'm making to the committee, that if you compare our military commission system, particularly the reform version, to an international court trial at The Hague, we're much more, for lack of a better word, liberal in terms of providing due process and protections to the accused than you would get if you're going to go to The Hague. And I have no problem with that, quite frankly. I think that's a good thing. Now, let's get back to what the courts are likely to look at in a military commission trial, Mr. Chris. I think the debate is a bit confusing. It's not so much whether the individual accused has a constitutional status as an American citizen, but the courts will look at these trials in terms of due process, and they will make a judgment as to whether or not it meets some minimum standard expected of American court. Is that correct?
That is essentially exactly what I was saying to Senator.
Yeah, and I think that is correct. And when you look at the history of military commissions, the World War II German saboteurs trials is not exactly the showcase you would want to use. Those trials were conducted in a matter of days from the time the evidence received to the judgment was rendered, and they passed scrutiny, but I think when we look back in time, that's not something we'd want to repeat. Is that your opinion?
I mean, I guess I essentially agree with what you just said, and I think Justice Scalia has referred to the Kieran case as not the court's finest hour, and so I think there is some question about whether you could apply those precedents straight on, given recent developments in the law.
Do you have a problem with the totality of the circumstances test if we fill in the blanks in terms of admission of statements?
No, on the contrary. I mean, I think the totality of the circumstances test is the right test. Of course, the administration's position is that it should be used to determine voluntariness, albeit voluntariness sort of that reflects the realities of a wartime situation. But I do think totality of the circumstances is what the judge would look at.
And the final thought here is about the difference between an Article III trial and a military commission trial. One of the big concerns that we have as a nation, Mr. Johnson, what percentage of the Guantanamo Bay detainees do you believe will be held off the battlefield but never go to a Article III court or a military commission trial?
Well, a percentage or a number is tough to say at this point, Senator. As I mentioned a moment ago, our review of these detainees is ongoing. I do think that we should all assume that for purposes of national security and the protection of the American people, there will be, at the end of this review, a category of people that we in the administration believe must be retained for reasons of public safety and national security, and they're not necessarily people that will prosecute.
Either the evidence is not the type you would take to a beyond a reasonable doubt trial, or it has some national security implications. And I'd just like to finish on this note. Admiral McDonnell, under domestic criminal law, is there any theory that would justify a indefinite detention of a criminal suspect without a trial?
In our own
Yes.
domestic law
Right.
that I know of, Senator.
In the military setting, is it a permissible behavior of a country to hold someone under the theory that they're a belligerent enemy combatant indefinitely if
Yes,
the
sir.
evidence justifies that finding?
Yes, sir, it is. That is a recognized principle of the law of war.
Do you agree with that, Mr. Johnson?
Yes, the Supreme Court held that in Hamdi in 2004.
Do you agree with that, Mr. Chris?
Yes, I agree that with Mr. Johnson, yes.
So to conclude, the only theory that would allow this country to indefinitely detain someone without a criminal trial would be the fact that we find them to be part of the enemy force, they're still dangerous, and are not subject to being released. Is that correct? A process that would render that decision.
Yeah, I'm not sure that dangerousness is actually even part of the initial judgment under the
That's true. It's not required.
I mean, I think their status, you know, and that's obviously being litigated now in the habeas cases. And I do think under Hamdi, you know, the court said that at some point that authority to detain could run out. But essentially, I agree, I think, with what you're saying, yes.
Thank you.
Thank you, Senator Graham. Senator Ben Nelson.
Thank you, Mr. Chairman. I think what you said in terms of geography is that, well, let me ask, is it geography matters in terms of Article 2 courts-martial or commissions, or geography may matter? In other words, where these military commissions hearings are held, if outside the continental United States, then perhaps a U.S. court would not, or could I say could not, intervene to provide extra protections under the Constitution. Mr. Chris?
The analysis really depends on a variety of factors, and it may be, I think it is the case that geography would have some impact on it, but it is very difficult to be precise and to predict exactly what would happen depending on...
Would there be a difference between Guantanamo and, let's say, Bagram Air Force Base, Bagram Base, in terms of geography and what the courts may do with an Article 2 hearing?
I want to be very careful. That is a matter that is currently in litigation, so I think I want to just be very careful to say that I think there could be some differences, but probably not go much further than that.
Okay. Mr. Johnson, what are your thoughts about geography?
Senator, much of this is uncharted territory in the courts in terms of what rights, if any, would apply to these detainees. I would say that it's our view that the detainees would not, whether in the United States or any place else, do not enjoy the full panoply of constitutional rights that an American citizen in this country would enjoy.
But on the continuum, what I hear you saying is, at the present time, under the current law, their rights are at this level, but it's not clear whether or not the courts could rule that the rights increase in numbers or in depth?
Well, let me try it this way. I think it is fair to say that it is our view that some level of a voluntariness requirement would be applied to statements that we would seek to offer in a military commission's case, military commission's prosecution, and that the ex post facto clause in the Constitution would apply if hypothetically these cases were prosecuted in the United States. I would note, however, that in practice, our military commission's judges have engaged in an ex post facto analysis anyway in assessing the prosecutability of certain of these detainees at Guantanamo. Judge Allred specifically went through an ex post facto analysis at Guantanamo, and I'm advised that in practice, many of our military commission's judges have gone through a voluntariness analysis in assessing the admissibility of statements.
I see. Mr. Johnson, can you speak to the progress of the Guantanamo Review Task Force? I think there were 779 people who were detained at Guantanamo. 544, as I understand it, have been transferred, with 229 remaining. Is that a fairly accurate number as far as you know?
Those numbers sound accurate to me, okay. Senator.
Well, do we know the status of the remaining detainees? I understand that there are those that could be tried under either Article 2 or Article 3 courts. But do we know how many have already been determined to be, let's say, under Article 3? Because as I understand it, Article 3 means that they would be coming to federal courts for prosecution.
At this point, we have not completed our review, so I don't have precise numbers for you. But I think it is fair to assume that at the end of the review, we will have detainees in the 5 categories that the President outlined in his May 21st speech. There will be some prosecuted in Article 3, or we would seek to prosecute in Article 3, some in military commissions, and some in that 5th category, some that are not prosecuted for various reasons, but for reasons of the safety of the American people and national security, we want to continue to detain pursuant to the authority granted by this Congress with the AUMF and the Supreme Court holding.
Do you have any idea when that review may be completed?
Before the end of the year.
This year?
Yes, sir.
Okay, yeah. Admiral McDonald, in your written testimony, you addressed the proffered amendment to the Military Commission's report or act reported out by your committee and indicated that for the most part addressed all of the matters that are and were of concern with regard to the 06 Military Commissions Act. Beyond the two issues that you highlight in your testimony, are there any other matters that ought to be addressed?
No, sir. Those are the two that I was referring to that we were unable to get back in 2006.
All right. I suppose in asking where the administration proposes to hold the military tribunals, Article 2 cases, is it fair for me to ask what the administration's view is of where to hold these based on the fact that geography may matter?
We've certainly made no decisions about that. Congress, in the supplemental that was recently passed, asserted its rights and prerogatives to know what we have in mind in this regard.
I suppose that's why I'm asking. But,
yes. And no decisions have been made, and we continue to consider various options.
And I assume there might be some advice and consent in conjunction with that?
Well, I think in the supplemental language, you've pretty much mandated that.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Nelson. Senator Martinez.
Mr. Chairman, thank you very much. Mr. Johnson, I'd like to ask, how will the executive branch make a determination of who gets tried under Article 3 and who may get tried in MCA?
Senator, that is something that Mr. Chris and I have actually been working on. As the representative of DOJ and I as the representative of the Department of Defense. And as Mr. Chris stated, the President stated, that where feasible, we would seek to prosecute detainees in Article 3 courts. We are working through an expression of factors.
Do you have a preference for an Article 3 court proceeding as opposed to a military commission proceeding? And is that by your preference, or is that by rights that may be imbued upon the detainee?
I would state it in terms of where feasible, we would prosecute people in Article 3 courts. But then you have to go through a variety of factors. For example, the identity of the victims. Is there a law of war offense that could be more effectively prosecuted versus a Title 18 offense? Identity of place of capture, for example. We're working through now a variety of factors for our prosecution teams to consider in terms of what direction to go. But I think the intent is to have a flexible set of factors because it is the case that many of these detainees can be viewed to have violated, those that are prosecutable, viewed to have violated both the laws of war and Title 18.
Admiral McDonald, I wanted to ask you about the appeal process as envisioned with a 4-tier process. It seems to me that if a defendant were charged with a federal crime, a U.S. citizen were charged with a federal crime somewhere in Florida, that defendant essentially has 1-tier appellate system from a federal district court to a circuit court of appeal with a very unlikely appeal to the Supreme Court. So a defendant in an American court, a citizen of this country, would not have as many appellate tiers as would one of the detainees in this instance. Is that correct?
Yes, sir, but remember, Senator, we're talking about conforming the commissions to the UCMJ and to our courts-martial process. And our court-martial process has, all of the services have a Court of Criminal Appeals as a first tier of appellate rights. After that, they appeal to the Court of Appeals for the Armed Forces, which is the first civilian court within our military justice system to which they can appeal. And after that, they have the right of appeal to the Supreme Court. So I think what we're saying is that if you want to the extent that you can, stay faithful to the UCMJ, that one way to approach it on appeal would be to allow the Court of Military Commissions review, either military judges that currently sit on that court now, or a combination of military and civilian judges, that they would have factual and legal sufficiency review powers. And then after that, you could either go into the federal system, to the D.C. Circuit as it's constituted today, or you could go to CAF and mirror the UCMJ system. Either of those paths would lead you ultimately to the Supreme Court. Now, can CAF do legal or factual sufficiency? Yes, Senator, they can. They're very skilled jurists. If the bill contains and continues to contain an appeal to the CAF, and that body is given both factual and legal sufficiency review, CAF can do that. So I think I would prefer the current system because our military judges are used to doing factual and legal sufficiency. But if you choose to go the CAF route, the CAF judges are capable of doing it.
You made recommendations with regards to how to handle classified evidence and also the standard for the admission of coerced statements. Do you have any other recommendations that you would make?
No, sir. Those are the two, and those really go to Senator McCain mentioned we've got to get these commissions moving and the practical aspects, and that's really what my two recommendations go to. We're finding, and this is through discussions with the chief prosecutor, that they're having a lot of difficulty in using Military Rule of Evidence 505 to govern classified evidence. The recommendation to use a CIPA-like process, a Classified Information Procedures Act type of process, I would call it CIPA Plus, where we import the good parts of MRE 505, which is to close a proceeding, a military commission when classified, close it to the public when classified evidence is being introduced, that we would take that in, add it to the CIPA rules where we have 20 years of federal practice that our judges can rely upon, that my personal opinion is that's probably a better approach to get these commissions moving. One of the complaints from the prosecutors is that the judges are demanding that they do everything with written submission instead of what CIPA allows, which is an ex parte hearing where you can go in before the judge, you can get the issues resolved, and we can move on. So that's why I recommended that the committee take a look at CIPA Plus as a substitute, perhaps, for that provision that talks about MRE 505. On the voluntariness piece, I do disagree with the administration on this. I think the committee's got it right on the reliability standard that exists in the bill. And I think fundamentally there is a difference between a voluntariness standard that grew up in a law enforcement environment, that's different than the law of war context we find ourselves in. And I am worried that a military judge that has a voluntariness standard imposed upon them is going to look at a statement taken at the point of a rifle when a soldier goes in, breaks down the door, and takes a statement from a detainee. I'm worried that they're going to apply a voluntariness standard to that. And I would argue, that's an inherently coercive environment when you have a rifle pointed at you. And I'm concerned a judge is going to look at that under a strict voluntariness standard and say, that statement doesn't come in. I would rather see this as part of a totality of the circumstances leading to, is the statement inherently reliable? And what I've proposed is a series of factors that would give the judge more guidance, perhaps, on how to do that analysis.
That's good. Thank you very much.
If you have actual language on your factors, you might want to share it with us, not now, but for
yes, sir. Yes, Senator, I will.
But you're basically in agreement with the legislation passed through the committee?
Yes, Senator, I am.
Thank you.
Senator Udall.
Good morning, gentlemen. Thank you, Mr. Chairman. Thank you, Senator McCain, Senator Graham. I know Senator Reid have all worked very, very diligently on this important set of questions. I have to note, can you imagine a lot of other countries in the world having this kind of a discussion? It's a tough discussion. It's been contentious, but here we sit in the best American tradition deciding something as important as this. I was a member of the Armed Services Committee in the House for 4 years, and I voted for legislation identical to the bill being proposed by this committee in the year 2006 that I thought struck a balance between military necessity and basic due process. When that bill didn't pass, and I voted against the Military Commissions Act that we're discussing today. And at the time, I thought that it risked tying up, that is the bill we passed, the prosecution of terrorists with new untested legal norms that didn't meet the requirements of the Hamdan decision. I thought it might endanger our service members by attempting to rewrite and limit our compliance with Common Article 3 of the Geneva Conventions. I thought it might undermine the basic standards of U.S. law, and it departed from a body of law well understood by our troops. Given that, I'm really glad we're here today looking at this opportunity to revisit this important legislation. Admiral McDonald, if I might turn to you, I was a member of the HASC almost 3 years ago, and you testified about the importance of reciprocity. And I want to quote you, and you said that you would be concerned about other nationals looking in on the United States and making a determination that if it's good enough for the United States, it's good enough for us, and perhaps doing a lot of damage and harm internationally if one of our servicewomen or servicemen were taken and held as a detainee. How do you think the Military Commission provisions in Senate 1390 measure up in terms of reciprocity? Are these provisions good enough for the United States in your view?
Yes, sir, Senator, they are. And I would go back to what Senator Levin said. You know, the two major points here that we have to be concerned about are the reciprocity issue and are we creating a just and fair system. And I think we need to be prepared to take any unlawful or unprivileged enemy combatant to one of these commissions. If we believe that we have created a fair and just process with this bill, we should not be shy about taking anyone before these commissions for, I think, Senator, just that reason. And I would be very comfortable having a U.S. service member subjected to these rules.
Thank you for that answer. Mr. Chris and Mr. Johnson, if I might turn to you and the question of sunset provisions. Mr. Chris, you state that the DOJ supports such a sunset provision. Could you talk a little bit more along those lines? And then, Mr. Johnson, I'd like to hear the DOD's views on a sunset provision, if you would.
Yes, thank you, Senator. With respect to the sunset, of course, I'm not representing the Department of Justice alone, but on all of my testimony is representing the administration as a whole. But our basic idea, I guess, that underlies the sunset, and we haven't specified any specific number of years, is as long as there's a continuity provision to allow pending cases to continue past the sunset, that it's a good idea for Congress to come back and take another look at this after the passage of some time and see whether there have been any developments that counsel some changes or a fresh look. And that's really, I think, what it boils down to.
Mr. Johnson.
Senator, I would agree with what Mr. Chris said, provided that it doesn't jeopardize ongoing prosecutions. We think in the administration a sunset provision is a good idea. We don't have a magic period of years, but given the reality of changing circumstances on an international level and lessons that could be learned from military commissions prosecutions in the immediate years forward, we think a sunset provision is a good idea.
Thank you for those insights. If I might, let me turn to a follow-up question on comments that the Chairman made in his opening statement on providing resources for the defense side of the efforts that we're discussing today. The Chief Defense Counsel issued a memo that I thought raised some troubling issues, and I'd be interested in views of each of the panelists on the current military commission system and whether the committee bill addresses the needs of the defense efforts appropriately. Maybe we start with Admiral McDonald and move back across.
Sir, I agree with the concerns expressed in the Senior Defense Counsel's memorandum. These have been long-standing concerns about resources, about access to experts, and I think it's something that needs to be addressed. I don't see anything, to your point about is it in the current bill. I don't see anything in terms of resourcing that would get at that particular issue. But I do think that that the Defense Council need more resources.
Mr. Johnson.
Senator, the legislation itself codifies a rule change we made in May to permit the detainee more latitude in selecting his defense counsel. But in terms of resources, at present, Colonel Massiola, who I consult with often, who's the chief defense counsel, has 43 military lawyers assigned to him, 5 civilian, and I'm told he's authorized to go up to 52. In response to your question about can we do better, one of the things that I'm focused on, that I'm concerned about, whether or not it's in this legislation, is something that I intend to push on, is making sure that our defense counsel are adequately trained in capital cases. In the civilian world, you have the concept of learned counsel. There are ABA standards for what are learned counsel for capital cases. And I think we owe it to the system to make sure that our defense counsel are adequately trained to handle capital cases.
Mr. Chris, my time's expired, so if you could be succinct, but I'd like to hear your answer.
Well, fortunately, I can be. This is primarily a Defense Department issue, and so I'd just like to associate myself with the remarks of my colleagues. One thing to point out is that the committee's bill does follow our rule change in allowing a choice of counsel. I think it doesn't define the pool from which that choice would be made, and that would be something I think we'd like to work with you on.
Thanks again, gentlemen, for your enlightening testimony, willingness to answer some important questions. Thank you.
Thank you, Senator Udall. Senator Reid.
Thank you, Mr. Chairman. Thank you, gentlemen. I just want to clarify some issues that have been previously touched upon. It's my understanding that in the Boumediene case in 2008, that the Supreme Court recognized the right of habeas corpus. That's a constitutional right. Is that correct, Mr. Chris?
Yes.
So there is at least one constitutional right that's been recognized in terms of enemy aliens, and that is this habeas corpus. Is that correct?
Yes.
And that's the only one?
So far, I believe that's the only right the Supreme Court has said applies there.
And the issue that we've talked about with respect to sort of the geography of these trials is that, and it's just, I guess at this point, get your opinion, moving some of this military commission to the United States might engender other appeals that could trigger requests for additional constitutional rights?
Well, I think regardless of where these cases are held, there will be appeals, depending on which appellate process is adopted, and there are a number of them under consideration, including in the bill. What results from those appeals, I think, as Mr. Johnson and I have both said, is very difficult to predict, because there's been quite a lot of development in the law over the last 50 years since commissions were last used. Obviously, there is some standard of due process that applies to a military commission. Exactly what that standard is, as I say, sometimes difficult to discern. In light of developments like the Boumediene decision, it can be, I think, also increasingly difficult to be sure. I do think geography may play a role in the rights or the procedures that are required, but again, it's hard to know for sure.
Let me also raise another issue. That is, as Admiral McDonald pointed out, the law of war recognizes the indefinite detention of combatants until the end of hostilities. My impression is that Hamdan reserved that issue and did not decide it. Is that accurate, Mr. Chris? Or?
I think you may be referring to Hamdi, which is the decision in which the court recognized the authority to detain under the law of war, and the court left open, I think, the question of whether that authority would at some point run out. And so I think that's an accurate statement.
And I would presume that the category of individuals, that fifth category of those that have to be held because of their potential, will have the right through habeas to periodically at least raise the issue of whether they still should be detained, Mr. Johnson?
Well, in fact, almost all, if not all, of the Guantanamo detainees are suing the government in habeas. And the President, in his May 21 remarks, stated with respect to that fifth category that there should be some form of periodic review, even subsequent to habeas proceeding, and that is something that we're working on now.
And frankly, one of the other reasons to move quickly but thoughtfully in this process of military commissions is that this is a way in which to ensure due process prior to a court deciding on the habeas case. Is that accurate?
That's a fair statement.
That's a fair statement. So I think it would serve us well to move with dispatch but thoughtfully on this legislation.
Yes, sir.
Admiral McDonald, you comment about the voluntariness standard and your concerns, legitimate concerns about it would confuse. It might tend to, I won't say confuse, but it might tend to complicate the decision making of military judges. But ultimately, aren't we sort of in a practical position trying to speculate about what the Supreme Court will hold? Because that's one reason why we're here today, doing this again.
Yes, sir. I would agree with everything that's been stated this morning about how unsettled the law is in this particular area. What I would propose is using voluntariness not as the only standard, but subsuming that as one of a number of factors, others being to the extent to which a statement is corroborated, looking at the reliability of the statement within the four corners of the document itself. My opinion is that the Supreme Court or federal court would recognize that there are fundamental differences between a standard that grew up in a law enforcement paradigm versus one that we're trying to understand in a law of war paradigm. And the reason I talk about this balancing test, this totality of the circumstances and the number of factors is, I think that will provide the judge with a kind of a guidepost. So, for example, if you're evaluating a statement that was taken at the point of capture, you might weigh voluntariness less because it's a more coercive environment than you would corroboration and the four corners of the document. As you become more attenuated from the battlefield, so for example, 6 months, a year after the detainee is removed from the battlefield and is in a facility like Guantanamo, then perhaps voluntariness in the judge's mind would be more important. But we would leave that to the military judge to determine on a case-by-case basis as he or she sees it.
Thank you very much, Admiral. If I may have one final question to Ms. Johnson. Is it your intention, or have you decided to either try give everyone who's in Guantanamo some type of due process, either military commission or a trial in Article III courts, or are there some people that simply will not get any procedure at all? They'll be deemed to be an enemy combatant who will be detained.
Well, putting aside anyone who has been released or may be transferred to another country in the future, I think it's accurate to say that the remaining population will either be detained because we've been upheld in a habeas litigation and they're subject to that periodic review I referred to a moment ago, or those that violate the laws of war that we feel we can and should prosecute will be prosecuted in a military commission, and those that can be prosecuted for violations of Title 18 will be referred to Department of Justice and Article III courts.
Thank you, Ms. Johnson.
Senator Hagan.
Thank you, Mr. Chairman, and thank you, gentlemen. As you know, over the course of many years, the former administration has released a number of detainees from Guantanamo, and obviously we are hoping that many of the other countries will take some of these detainees that are remaining. But we need to be mindful of the fact that the countries in the region, such as Yemen, are currently incapable of mitigating the threat posed by the returned Guantanamo Bay detainees, whether the country lacks the appropriate institutions or mechanisms of enforcement, such as a counterterrorism law, or just the ability to prosecute these detainees. And additionally, many countries in the region may not be willing to accept them. I think we need to work with the countries in the region that have a proven track record in rehabilitating the terrorists to accept detainees transferred from Guantanamo Bay. And according to the Office of the Secretary of Defense, Saudi Arabia remains one of the most reliable counterterrorism partners in accepting detainees that have transferred from Guantanamo Bay. The Saudis have actually institutionalized a rehabilitation program that is developed by the Minister of Interior to de-radicalize and rehabilitate the former detainees for reintegration into the society in Saudi Arabia. And according to the Office of the Secretary of Defense, efforts are underway to convince Saudi Arabia to accept some of the Yemeni detainees that have Saudi tribal affiliations into the kingdom's rehabilitation program. My question for all of you is, how is the Department of Defense addressing the problem that many countries in the region are just simply not capable of mitigating the threat posed by the Guantanamo Bay detainees, and they lack the appropriate institutions and mechanisms to prosecute them? And also, can you provide your opinion on working with the countries in the region, such as Saudi Arabia, to accept these Yemeni detainees that are transferred from Guantanamo Bay that share the same tribal affiliations?
Senator, I agree with just about everything you said. Many people do not understand that it's not as simple as, oh, XYZ country is willing to take the detainee back, so we can send them back. There needs to be in place an adequate rehabilitation program where the circumstances warrant, or the ability to monitor in that accepting nation so that the detainee doesn't simply return to the fight, and that we minimize to the fullest extent possible any acts of recidivism for those who are transferred or released. The safety of the American people is the utmost concern. We believe strongly that rehabilitation programs like the one you referred to are something that we should encourage, promote, and it's something we're very, very focused on.
Mr. Chris?
I agree with everything that Mr. Johnson said. It is absolutely essential that when we transfer these people to foreign countries, that we do so under conditions that ensure safety. And the rehabilitation program that the Saudis have is an excellent program, from what I understand.
Senator, I would agree with Mr. Johnson on this, that and particularly with our military members, we're concerned about returning fighters to the battlefield. And so this is a big issue for us. But I think the way Mr. Johnson characterized it is exactly right.
Thank you. Also, I think that we need to be mindful that although the interrogation detainees produce obviously valuable information and sources of intelligence, we also know that they can compromise the ability to prosecute detainees, obviously, if the evidence obtained is through an interrogation method that would involve torture. Mr. Chris, can you just describe the process in which the Department of Justice is reviewing the evidence associated with each of the Guantanamo Bay detainees to determine if they can, in fact, be prosecuted? And how is the Department of Justice working with the Department of Defense in this regard?
Yes, I'd be happy to do that, Senator, and Mr. Johnson and I are working closely together on this. There is obviously the review by the task force that was set up by the executive order that makes judgments about whether cases are potentially prosecutable. At that point, they need to be reviewed both by the Justice Department and the Defense Department working together to try to figure out, are these cases really appropriate to indict, either in an Article III court or to bring before a military commission. And as Mr. Johnson and I have talked about, this is a fact-intensive judgment. It requires a careful assessment of all of the evidence, identity of the victims, location of the offense, and a variety of other factors. I mean, I would point out, I guess, that these kinds of forum selection choices are not unfamiliar to federal prosecutors. They have to make these kinds of choices in other cases as well, whether it's between federal and state or U.S. and foreign or even UCMJ and Article III courts. So there has to be a process where the case is really carefully reviewed and worked up by a joint team, and then a judgment made about whether and where it ought to be prosecuted.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Senator Hagan. We're going to have a 2-minute second round with this panel. I wish it could be a lot longer. First, to Admiral McDonald. I didn't ask you this question the first round, so let me ask you now. Do you believe that our language conforms to the Hampden standards?
Yes, sir, I do.
And secondly, Admiral, I think that Mr. Johnson said that the preference here would be to have more Article III trials. We will, I think, hear some testimony that all the trials should be Article III, that there shouldn't be any military commissions. And I'm wondering if you could tell us, as a kind of a military man, but a JAG officer in the Navy, why military commissions at all? Why not try everybody under Article? What are those circumstances which make it difficult that I think Mr. Chris and Mr. Johnson are working through as to why would you want to try anyone under military commissions or need to try anybody with military commissions?
Well, Senator, I think again it goes back to, the Uniform Code of Military Justice and federal law is designed for a different model. It's designed for law enforcement. We're in a wartime environment.
Give us the practical parts of that environment which would lead you to conclude we ought to have military commissions try people, or that we need to have a military.
Well, again, Senator, it would go to that very coercive environment when we're relying upon our soldiers to go into a dangerous environment where, in many instances, they have to break down doors, and we're worried about their safety. They're worried about it. We don't want them to have to stop and think about giving Miranda rights or giving Article 31B rights under the UCMJ. We don't want them thinking, in my personal opinion, about whether or not the statements that they are getting from someone in a house that they've just broken into, whether that statement is purely voluntary or not. And I think that's recognized, and the Supreme Court recognized that in the Hamdan case, that there are these unique circumstances that come up in a law of war environment that just cannot be handled under two different systems that were created for a completely different reason. The other thing that I would say, sir, is, and this is to your point in your opening about a fair and just process. I think we need to be clear. As we go forward with these commissions, we need to feel that these commissions can try anyone that fits within the jurisdictional definition that you've put in the bill, the personal jurisdiction section. We ought to feel very comfortable taking anyone. Now, I understand that the President prefers Article III courts, but in my opinion, when we leave here today, we ought to be looking at this bill and saying to ourselves, it is fair and just. To Senator Udall's question, we would feel very comfortable having our own service members tried under this kind of a process. And I don't think we should kid ourselves. Anybody should be able to, any enemy combatant should be able to be tried under this process.
Admiral, just quickly, relative to your totality of the circumstances, point as to whether or not a statement obtained is coercive. In our bill, a statement that is obtained through cruel, inhuman, and degrading treatment is not admissible, period. What you are suggesting is that instead of adding a, quote, voluntary standard to that there be something much more carefully defined so that a judge can look at the totality of the circumstances to take into account these factors involving warfare and the use of force. Is that accurate?
Yes, Senator. We pushed in 2006 to eliminate the discrimination between statements taken before December 30th, 2005, the date of the Detainee Treatment Act, and a different standard opposed to statements after. Your bill eliminates that distinction, and so statements taken from under torture are eliminated. And CID statements, they're eliminated. I'm talking about some level of coercion below those two standards.
And torture is defined by the Geneva Conventions.
Yes, sir.
Now, fine, there's one more thing I have to clear up, and this is this question of location. Our bill clearly is not going to distinguish as to what the procedures are dependent on where the location of the military commission is. I mean, there's no way that our statutory language can make that distinction. I think that you were pressed, Mr. Johnson, and I think Mr. Chris to some extent, to describe where it might make a difference, I guess, in terms of a judicial or court or a judge's opinion as to where, depending on where the location is. I don't see that at all, I must tell you. I don't see how the location of a military commission's hearing can have an effect at all. It won't have an effect, nor can it, in the way we write the procedures. Finally, however, on the other side of the coin, if you're going to try people for Article 3 crimes, which is your preference, there's no way, practically, those folks can be tried in Guantanamo. You cannot have a jury impanelment that takes months with hundreds of citizens dragged down to Guantanamo to live while a jury is being impaneled in an Article 3 criminal case. So there are many reasons why we need to bring people, if we're going to try them for crimes under Article 3, which we want to, why you need to bring them to the United States as a practical matter. And as far as where a military commission is held, I don't see that there is a difference. You've been asked for the record to give us any thoughts on that, and of course that request I know you will honor and give some thought to, but I just don't offhand see that it could make any difference as to the procedures as to where a military commission is held. That's a statement, it's not a question. I'm way over my time. If you want to react to that for the record, because go on, Mr. Chris, you're just...
Well, I just say first, I agree with you that it's hard to imagine an Article 3 prosecution occurring at Guantanamo. Second, in talking about location, Jay and I have been, I think, perhaps cautious just because these are difficult issues, and we will get you something for the record. But third, I just want to make clear, despite the difficulties, our best prediction is that voluntariness will be required as a matter of due process here. It's a voluntariness standard that is based on totality of the circumstances, and it's very similar, I think, to what Admiral McDonald was talking about, that is, you have to take account of the realities of war. But I do want to make clear that we've come to that conclusion.
That is the position. The administration will welcome both language from both of you on that, but our bill, as it stands, does incorporate the Geneva Conventions. Senator Graham.
Thank you, Mr. Chairman. I think we'll find some common ground here about the evidentiary standard as far as statement goes. I think we both view it the same, that they're, Admiral McDonald, you described the situations very, very well. When you're in detention outside the battlefield, the analysis will be different. If you're in the middle of a firefight, the judges should be able to accommodate those circumstances. And I don't think there's really a whole lot of difference, Mr. Chris, between you and Admiral McDonald. We'll get there. But this location issue is very important because the politics of this, for lack of a better word, Mr. Johnson, is it your view that closing Guantanamo Bay would be an overall benefit to the war effort and starting over on detainee policy?
It's my view, Senator, which is also the view of the administration, but it's my view that closing Guantanamo enhances national security.
Well, I would just like to, maybe being the odd guy out as a Republican, I believe that also simply because General Petraeus, Odinero, and every other combat commander has said that being able to start over with detainee policy would take a tool off the table used by our enemies, because Guantanamo Bay, quite frankly, is the best-run military prison in history right now. Do we all agree with that? That the current state, Admiral?
Yes, sir, I do.
Mr. Johnson?
I've been there. The professionalism of the guards at Guantanamo is remarkable. I've visited civilian clients in a few Federal Bureau of Prisons, and I agree that the professionalism of our personnel there is really remarkable.
I, too, have visited Gitmo, and I also was quite impressed by it.
And to the Guard Force families who may be listening, what your loved one goes through every day at Guantanamo Bay is a real sacrifice. That is a tough place to do duty. But having said that, it is what it is, and starting over with detainee policy, I think, could help the country. Mr. Chris, you said one of the goals of a reform commission is to let the international community know that there's a form of legitimacy to the commission that we haven't been able to have otherwise. Is that correct?
I do think it is important, and I take it to be one of the main reasons that we're doing this work, that the committee is doing this work, is to enhance the legitimacy.
I totally agree. But the last thought is, I just can't believe, quite frankly, given the Supreme Court cases, that if you close Guantanamo Bay, move the detainees within inside the United States, and performed a military commission trial like we did in World War II, that there'd be a substantial difference. What I don't want to have taken away from this hearing is that if we close Guantanamo Bay and move the detainees within the United States, that they're going to be conferred, there will be conferred upon them a plethora of legal rights they wouldn't have otherwise. And can y'all just address that?
It may be helpful if we say this. I mean, there's a number of, I think, relatively modest differences between the committee's bill and the administration's proposal, but as you've said, they're not vast, and we do approve of and support the bill. The changes that we're recommending, we think, would be ample to survive constitutional review, even if the commissions were held in the United States.
So just the location alone is not going to change the dynamic the court would apply in a dramatic way.
No, and we think that what we're proposing will pass muster comfortably in the United States.
Senator, we're not suggesting, and I want to emphasize that the full range of constitutional rights would apply depending upon location. We have referred in this hearing today to voluntariness, and Mr. Chris is right. When you look at the suggestion from the administration on a totality of circumstances voluntariness test, it's really not that different from what Admiral McDonald has described.
Senator, I think, as you've just pointed out, this is really coming down to that particular right and the voluntariness test. I would align myself with Mr. Chris that bringing the situs of the military commission in terms of additional constitutional rights should not matter in this, and that I think we probably can reach some common ground between what I would consider to be a balancing test using voluntariness and what the administration's position is right now.
Thank you, Senator Graham. Senator Lieberman.
Thanks, Mr. Chairman. Chairman Levin asked Admiral McDonald the question, a rhetorical question of why would you try any of these people in a military commission setting, as our bill requires? And I thought your answer, Admiral McDonald, was compelling and very principled. And to a certain extent, I suppose what I really want to do is ask the question from a different perspective of Mr. Johnson, Mr. Chris, which is, why would one prefer, why would anyone prefer to try people apprehended for violations of the law of war in an Article III federal court, as you said, Mr. Johnson? I was disappointed with your answer, and it kind of pulled me back a little bit from my feeling of appreciation toward the administration for accepting a role for the military commissions in handling these people. I mean, the fact is that from the beginning of our country, from the Revolutionary War, we've used military tribunals to try war criminals or people we have apprehended, captured for violations of the law of war. And again, I think the unique circumstances of this war on terrorism against the people who attacked us on 9/11 may have led us down, including the Supreme Court, some roads that are not only, to me, ultimately unjust, but inconsistent with a long history that we've had here. We talked before about how the military commissions are not only within the Hampden decision, but certainly within the Geneva Convention, which is the international standard for fairness of justice in handling people captured during war. So why would you, in light of all that, say that the administration prefers to bring these people before Article III federal courts instead of military commissions, which are really today's version of the tribunals that we've used throughout our history to deal in a just way with prisoners of war?
Senator, please don't misinterpret my remarks. I applaud this committee's effort and this committee's initiative to reform the Military Commissions Act. I think that military commissions should be a viable, ready alternative for national security reasons for dealing with those who violate the laws of war. And I'm glad we're having this discussion right now, and I thank the committee for undertaking this. And as we said, by and large, we definitely support what you're doing. The President's made that clear. When you're dealing with terrorists who's, and I'm going to say this on behalf of the administration, when you're dealing with terrorists whose one of their fundamental aims is killing innocent civilians. And so it is the administration view that when you direct violence on innocent civilians, let's say in the continental United States, that it may be appropriate that that person be brought to justice in a civilian public forum in the continental United States, because the act of violence that was committed against the civilians was a violation of Title 18 as well as the law of war. So we believe strongly that both alternatives should exist.
Well, I hear you. I respectfully disagree insofar as the administration has stated today a preference for trying these people in Article III courts, because I think based on what you've just said, we're essentially, the effect of it is to give these war criminals, people we believe are war criminals, that's why we captured them, the greater legal protections of the federal courts because they have chosen to do something that has pretty much not been done before in our history, which is to attack Americans, to kill people here in America as they did in 9/11. Civilians, innocents, doesn't matter. And to do it outside of uniform. So I think it puts us in a very odd position that we're giving these terrorists greater protections in our federal courts than we've given war criminals at any other time throughout our history, even though, in my opinion, they are at least as brutal and inhumane, probably more brutal and inhumane than any war criminals we've apprehended over the course of the many wars we've been involved in. So I think we end up, yes, it may be also an act of murder to have killed people who were in the trade towers on Twin Towers on 9/11, but it was an act of war, and the people who did that don't deserve the same constitutional protections in our federal courts that people who, may be accused of murder in New York City do. I say New York City because the attack was there. So I'm over my time, and this is a very important discussion, which I would look forward to continuing with respect with you and others in the administration. Thank you.
Thank you, Senator Lieber. Senator Martinez.
Thank you, sir. To follow up on that, I think that it's fascinating for us to discuss a person like Khalid Sheikh Mohammed, who didn't wear a uniform and, in fact, inflicted great harm upon civilians, not only here but in other parts of the world, and considers himself to be a part of a movement, of a political movement, that we would then consider the person like that to have a preference for trying him as a criminal under Title 18 in an Article III court as opposed to in a military tribunal, and accord him an additional set of legal rights. And that begs another question. If we're doing Article III trials, as the chairman was suggesting, we then also are talking about closing Guantanamo by the end of the year. There's no way for 220 some odd people to be processed through some proceeding, whether Article III or military commissions, in that time frame. So where will they then be I guess they'll be here. And what about those that are then acquitted? Where do they go? What happens to them? Would you mind touching on those issues?
You're correct. You can't prosecute some significant subset of 229 people before January. And so those that we think are prosecutable and should be detained, we will continue to detain, whether it's at Guantanamo or someplace else. The question of what happens if there's an acquittal is an interesting question. We talk about that often within the administration. I think that as a matter of legal authority, if you have the authority under the laws of war to detain someone, and Hamdi decision said that in 2004, that is true irrespective of what happens on the prosecution side.
So therefore, the prosecution becomes a moot point?
No, I'm not saying that at all. I'm saying that you raised the issue of what happens if there's an acquittal.
Right.
And in my judgment, as a matter of legal authority, they're different. You could get there different. There might be policy judgments one would make, but as a matter of legal authority, if a review panel has determined this person is a security threat, and they've lost in their habeas, and we've gone through our periodic review, and we've made the assessment the person's a security threat and should not be released. If for some reason he's not convicted for a lengthy prison sentence, then as a matter of legal authority, I think it's our view that we would have the ability to detain that person. Whether in fact that actually happens, I think would depend upon the circumstances and the facts of the particular case. But as a matter of legal authority, I think we have law of war authority pursuant to the authority Congress granted us with the AUMF, as the Supreme Court interpreted it, to hold that person, provided they continue to be a security threat. And we have the authority in the first place.
Thank you. My time is up, but I will just conclude with a comment that I truly believe that these are not criminals, that these are people engaged in a very profound battle against this country as part of a non-state actor for some of them, but that nonetheless do not really belong treated as criminals, but as people that are involved in something much deeper and greater than that.
Thank you, Senator Martinez. Senator Udall.
Thank you, Mr. Chairman. I'll be brief. I want to thank three panelists for your excellent testimony. I want to also acknowledge the fact that the civilian judicial system is interfacing and working with the military judicial system. And I speak as a non-lawyer, so I'm already getting into deep water here, but it seems to me that judicial system is a living, evolving, growing thing, if you will. And we're working here to make sure that it's nurtured. Another way to look at this perhaps is you've got two different kinds of software systems that we're trying to integrate and understand together. So again, I want to thank the civilian and the defense establishments for working together. Any time I have remaining, Mr. Chairman, I pre-yielded to the great questions from the JAG officer that sits on the Senate committee, Senator Graham, who I thought has been very, very informative, very incisive with his questions and comments today.
Well, I understand. We do have two legal systems going to bear. Habeas rights have been granted to Guantanamo Bay detainees. While I don't agree with that, under the bill that Senator Levin and I wrote, every detainee would wind up in federal court, the D.C. Circuit Court of Appeals. The Supreme Court ruled that habeas rights apply to the detainees. We need to look as a nation about creating uniformity to these habeas rights. Do we as a nation want habeas petitions to allow for lawsuits against our own troops? A medical malpractice case was brought under the old habeas system. I think, Senator Udall, we can streamline the habeas process. There is a role for an independent judiciary. And I would just like to conclude with this. No one should be detained in America for an indefinite period of time that doesn't go to a civilian court or a military court without an independent judicial review. I don't want people to believe that folks are in jail because somebody like Dick Cheney, or you fill in the blank with a politician, said so. It doesn't bother me at all that all of our cases will go to civilian judges, and the military and the CIA has to prove to a civilian court that these people are dangerous and they're part of the enemy. Once that's been done, then I think it's crazy just to arbitrarily say you got to let them go. If our intelligence community, upon a periodic review annually had, believes that they present a danger to this country, I think it would be crazy to say you got to let them go, because you don't under the law of armed conflict. But just to end, Senator Udall, we need a hybrid system. We need civilian judges involved in this war, because it's a war without end. As the President said last week, there will never be a definable end to this war. An enemy combatant determination can be a de facto life sentence. I don't want to put people in a dark hole forever. I want them to have a way forward based on their own conduct. Some of them will be able to get out of jail because they've rehabilitated themselves, and some of them may, in fact, die in jail. But I want it to be a process that's not arbitrary, that's not based on a politician saying so, but a collaborative process with an independent judiciary legitimizing our actions. I think that's what this country has been lacking, and that's what we needed to go forward. That's not being soft on terrorism. That's applying American values to this war.
Thank you. Senator Reid.
Thank you. This has been a very thoughtful discussion, and there's been a discussion about the value of trying everyone in a military tribunal, military commission, or trying people in civilian courts. And I think, just for the record, there is a value to trying some of these individuals as in civilian courts, because they are criminals, and because when they try to claim the mantle of warrior, and that is sort of feeding into their appeal out in the greater Islamic world. But in fact, they're criminals. They've committed premeditated murder, and in that situation, I think they should, if we can mount the case effectively in court, we should not only do that, but they should be not only convicted, but also sort of identified as criminals, not as soldiers, not as warriors, etc. Now, there are other cases where captured on the battlefield or because of practical considerations, the military tribunal will work. And I just wondered, Admiral McDonnell, as a uniformed officer, do you have a reaction to that?
Senator, I guess my only point would be this, is that I think we need, at the end of the day, to have full faith and confidence that what we're creating in the military, in this bill, is a fair and just process. I am sensitive, too, that there may be situations where going to an Article III court, going to federal court, may be the right decision given the facts and circumstances that exist in a case. But I think it's absolutely vital that when we leave here at the end of the day, it's not because we believe that what we've created is a second-class legal system. We need to look at this, that this can stand alone in the world, and we are willing to be judged by what we're putting together today. And that's my only point, is that you ought to feel very comfortable sending anybody to these commissions process with these changes, because we believe it's a fair and just system.
The ultimate test would be if an American serviceman or servicewoman was subject to these procedures, we would consider them to be appropriate.
Yes, Senator.
Thank you.
Thank you. I'll just conclude by saying what our bill does not address, does not purport to decide or address. One, we do not decide whether a person will be tried, who's going to be tried, is tried by an Article III court or a military commission. We've been told there's going to be some of each for various reasons. We do not make that decision in this bill at all. Don't try to, don't purport to. Secondly, we do not address the question of where a trial takes place. That is not addressed in this bill. Third, what we do is address the procedures that would apply where there are military commission trials. And it's pretty obvious to me, as chairman, that those procedures will apply regardless of where the military commissions is held. There can't be any difference in the way we write a bill on that, and I disagree with the suggestion that somehow or other it will make a difference in terms of a court ruling, Supreme Court or otherwise, as to whether or not a military commission proceeding is held in the United States or in Guantanamo. I just, as a lawyer, cannot imagine the Supreme Court or any other court saying, well, this commission was held in one place, therefore one rule, constitutional rule applies. If it were held in another place, a different constitutional rule applies. Given what the court has decided in Boumediene and what the court has decided in Hamden, I just can't imagine there would be any difference in that decision, whether trial court or Supreme Court, as to where this military commission proceeding took place. Finally, on the voluntariness issue, hopefully we can come up with some common language on that, but in any event, we have language in the bill which incorporates the requirements of the Geneva Conventions in terms of coercion, in terms of whether or not a statement can be used against a defendant. Thank you all very much for your wonderful testimony here, your very carefully thought out testimony. We made part of the record. We'll have some additional questions for the record, and we'll now move to our second panel.